Disputes. They're a part of every economy, from civil to commercial to private family matters. Over the past 3 decades, we've seen countless efforts by lawmakers to increase the recourse to mediation in order to better meet the interests of litigants and at the same time make the civil justice more efficient and stimulate the growth of economy. Governments and international donors have invested collectively millions of dollars and euros in projects and awareness campaigns on mediation. However, statistics indicate that in the vast majority of countries, mediation is, on average, still used in less than 1% of court cases.
To try to solve this problem, in 2013, the Italian legislator introduced the required initial mediation session with an easy opt-out in some civil dispute matters as a precondition to recourse to court. This was an addition to the 2 traditional recourses to mediation by voluntary agreement and judge referral.
The required initial mediation session is a provision of the law that proved to work far better than the other 2. Let's compare the results of the 3 types of recourses. The first is the recourse to mediation by voluntary agreement. The litigants should agree in writing to attempt mediation within a mediation provider accredited by the Minister of Justice. Despite litigants benefit from fiscal advantages and tax credits, this recourse only generates around 9% of all mediations in Italy. The second type is the recourse to mediation ordered by a judge. If a case is pending in a trial court or court of appeals, judges may, at their own discretion, order all parties to attempt mediation. This occurs once they have assessed the case's nature, stage of the trial, and parties' conduct. This constitutes just 1% of mediations in Italy. Finally, the third type, the required initial mediation session. In certain disputes matters such as real estate ownership, inheritance, medical malpractice, or banking and insurance contracts, here the plaintiff must first file a mediation request and attend an initial session with a professional mediator and the defendant for a small filing fee before court recourse is granted. Should the defendant not attend, the judge will sanction in the future proceedings. If any party present at the initial session decides not to proceed, they have fulfilled the prescribed requirement and may opt out. If all parties do proceed, fees depend on the case's value and the process can take up to 3 months. The required initial mediation session accounts for a massive 90% of mediations in Italy, around 180,000. When the parties decide to proceed to full mediation, the average success rate is 50%. As results, course case filings of this nature have dropped from -30% to -60%.
Thanks to the required initial mediation session, Italian mediators are now administrating hundreds of thousands of mediations every year. In most cases, during this session, all litigants and their lawyers voluntarily agree to try the full mediation process. This wouldn't be possible without the opportunity for the mediator to meet directly with all parties gathered in the same room at the same time.
The required initial mediation session, with an easy opt-out, has proven its worth time and time again, generating a substantial number of mediations in a given jurisdiction over a short period. With a step-by-step introduction in different dispute matters and with relevant adaptations for local needs, the required initial mediation session can and will prove invaluable on a global scale. This was just the beginning.